Hello, everyone, and welcome to today's webinar presentation, Essential New York Independent Contractor Issues. While engaging an independent contractor seems like a quick and economic solution for many businesses, this area of employment law presents a host of challenges, especially in New York. With state-specific determinations and tests, sweeping new statewide legislation, local laws, endless pitfalls, it is increasingly more difficult for employers to properly classify independent contractors. During today's presentation, Paul Piccigallo, Rick Reyes, and Matthew Capobianco will walk you through these essential New York independent contractor issues. Before getting further into today's topic, I would like to take a moment to introduce myself and my organization. My name is Stephanie Zielinski, and I am the Marketing Director of ComplianceHR. You may recognize me from the email invitations you received for today's event, but to prevent a few popular questions from trickling into the Q&A box, I would like to share that everyone registered for today's event will receive an email from ComplianceHR webinars, which includes the recording and the slide deck. Now, a bit about ComplianceHR for anyone who may be unfamiliar. ComplianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler Mendelson. ComplianceHR delivers expert employment law guidance in a fraction of the time. Our goal is to simplify the complexity of employment law, something we'll learn a lot about during this presentation. To achieve that goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics like employee overtime, independent contractor classification, employee handbooks, onboarding, leave, and many more. Today, I would like to introduce you to Navigator Independent Contractor, also known as Navigator IC. This solution helps you efficiently determine whether or not an employee is an independent contractor. It's a simple assessment that draws from an engine of court decisions, COL opinion letters, and information provided by Littler's comprehensive database. This tool analyzes fact patterns and all applicable state and federal regulations. If you're interested in learning more, a survey will pop up on your screen. You may have to exit full screen mode to see it. If you'd like to receive a complimentary demo of the Navigator suite, simply answer yes, and I can send your contact information on to our team of experts. In addition to a demonstration of our solutions, you may be eligible to receive a free trial of our products, so you can see precisely how much time and money they'll save you. If you're not sure at this time, I'll ask again once more before we end today's presentation. While that poll is running, I wanted to share a bit more about how this solution can help you lower your risk of independent contractor misclassification. On screen, you'll see an example of the actionable risk assessment, including ways that you may be able to lower your risk. This solution also provides a summary of applicable national and state laws and a transcript of the questionnaire. So if you're looking for an affordable way to navigate the complex independent contractor laws in New York or any state, this tool is a great solution. I'll leave the poll open for just one more moment while I have the pleasure of introducing today's presenters. Paul Piccigallo, Rick Reyes, and Matthew Capobianco focus on wage and hour laws, employee misclassification, and employment litigation, all being based out of New York, these three experts on today's topic. Thank you so much for presenting today, guys. And Paul, I will pass it over to you.
Thanks so much, Stephanie. And thank you, everybody who's joined us. Good morning or good afternoon, depending on where you are. And thanks, Stephanie, for that intro on ComplianceHR. For what it's worth, I have used it. I know my clients have used it. I think it is a great tool. And I'd recommend you try it if you have any interest. So my name is Paul Piccigallo. I am a shareholder at Littler's New York City office. I'm joined by my colleagues Matt Capobianco and Rick Reyes, who are senior associates at Littler's Long Island and New York City offices, respectively. Matt, Rick, and I all have a primary practice area of wage and hour law, in particular New York wage and hour issues. In my prior life, I was an attorney at the New York State Department of Labor, where I helped craft some of the regulations in effect today for wage and hour. So if you find any of those regulations confusing or even nonsensical, trust me, you are not alone. Unfortunately, you might partially have me to blame. As for Matt, he has focused his entire career on wage and hour and class and collective actions. He's handled hundreds of wage and hour cases throughout his career. Rick actually recently joined our New York City office from Littler's Los Angeles office, and as a result, He has experience handling wage hour issues, in particular independent contractor issues under both California and New York law, particularly in the hospitality and retail industries. And finally, as you folks might know, the three of us recently co-authored an article on our firm's website regarding the new independent contractor law that went into effect in New York. This law, the Freelance Isn't Free Act law, will be discussed in detail today. But of course, feel free to read the article. If you need more details, reach out to us directly if we're unable to answer any questions you have today. So let's jump into the agenda. Sorry about that. Back one. There we go. Another ambitious agenda today, which has become a recurring trend. If you followed any of our Littler webinars, we hope to cover it all in the time allotted. Our goal is to really cover three general categories: the tests used in New York to determine whether an individual is an independent contractor or an employee, the newly passed New York State Freelance Isn't Free Act and its requirements for entities that are engaging independent contractors in the state, and third, the risks of misclassification, that is, classifying somebody as an independent contractor when they really legally are an employee, and best practices for working within the independent contractor model. Please submit questions throughout. We'll be tracking them. We'll be doing our best to answer them at the end of the presentation. Again, if we don't have time to answer questions, rest assured we will follow up with you separately after the presentation. So big picture, 10,000-foot level. Workers can be classified as an employee or an independent contractor. Hopefully you know that much. We'll get much more detailed with respect to this classification. Matt will be talking about why it could have extremely significant implications if one makes the wrong determination, that somebody classifies somebody as an independent contractor, but they're really legally an employee. So the basics as to who is an independent contractor. As us lawyers say, a bona fide independent contractor relationship. Really that it's something that will withstand scrutiny from a court or an administrative agency. Well, unsurprisingly, the key is that it is an independent relationship. A true independent contractor, really, if you're going to take anything from this, it's that they should have supervision, direction, and control over the means and the manner of the services they are providing. Generally, the more supervision, direction, or control that the engaging entity exercises, the greater chance a court or administrative agency will find that the individual was not an independent contractor, but instead an employee. Very important point to make here. The contractual language between an engaging entity and an independent contractor is not determinative. So that means just that you have an independent contractor agreement that's in writing. It says clearly and explicitly, this is an independent contractor relationship. It could be helpful if you later have to defend that relationship, but it is not determinative. You actually have to look at the actual relationship of the parties. Similarly, an independent contractor preference to be an independent contractor, that they want to be paid 1099, that they think that they're an independent contractor, isn't by itself determinative either. That's one factor that courts and agencies will consider, but they're always going to look at a variety of different factors to really determine who has the supervision, the direction, and control in the relationship. Speaking of administrative agencies, I'll just share some anecdotal experience from my prior work at DOL, the State Department of Labor. Independent contractor misclassification is always a very high priority for state administrative agencies. Matt will discuss that a little bit more later, but I personally handled countless matters where the engaging entity and the alleged independent contractor had very clear written agreements stating this is an independent contractor agreement. But it wasn't enough if you actually looked at the facts of that relationship to sustain a finding of an independent contractor. In practice, there is a default assumption by many courts and especially the administrative agencies, Department of Labor, other agencies as well, that an independent contractor really is an employee. Most agencies, when they do an audit, are going to be thinking, I think that this employee is a W-2 employee in reality, or excuse me, this individual is a W-2 employee, it's on you, employer, to rebut that. So prove it to me, which is why it's very important at the outset of that engagement to ensure that you've actually looked at that relationship and taken steps to ensure that those folks are properly classified. So what are common signs of a true independent contractor status? Again, importantly, none of these factors are determinative. That means that just by meeting one of these factors doesn't win or lose the determination. Courts and agencies look at it in combination. They'll review a number of signs and factors, which we'll discuss later in terms of how they weigh that. But as you'll just see by reviewing these different signs, they all kind of point to the same thing: the independent contractor exercising supervision, direction, and control over their work. What I always find interesting with these factors are, some of the bottom ones: contract with competitors, contract with customers, promote their own business. There is this real entrepreneurial factor that is built into an independent contractor and their work and a true relationship. Courts and agencies are looking at whether or not this individual and their company are, for example, promoting their own business. Do they have business cards? Do they have solicitations? Do they put ads in industry periodicals? Are they permitted to work with competitors? Are they investing in their own business to expand their opportunity for growth and profit? Are those expenses borne by them and not the entity with whom they're contracting? An important factor with this is to consider, are they actually engaged as a sole proprietor? Is it an individual, or do they have their own operating company? Again, not determinative, but something that courts and agencies look at. So certain terms that just do not apply to independent contractors, or shouldn't. You'll note today that I haven't yet used the term, or maybe I did mistakenly, quote, the employer. There is no employer in an independent contractor relationship, a true independent contractor relationship. There are two parties, two engaging or contracting parties. I reference the, engaging entity. It's important, though, because they are so factually different in terms of what that relationship is and what it entails. You'll see some terms here in the bullet points that are very common for the employment relationship. None of these really should apply to an independent contractor relationship, or in whole part should apply to an independent contractor relationship. And a bona fide independent contractor is not employed. They're engaged or they're contracted. One term to remove from your lexicon today, if you take anything from this presentation, the 1099 employee. I've dealt with that many times. It's kind of like an oxymoron. Somebody who's paid on a 1099 as an independent contractor by their nature is not an employee. An employee is subject to W-2 tax withholdings. It's just entirely separate, amongst other factors that make them separate. In terms of discipline and supervision, it becomes a little interesting depending on the type of work that the contractor is engaged to perform. Engaging entities are allowed to review the work performed by independent contractors. Independent contractor agreements can provide for permissible review before payment or other reconciliation provisions to ensure that the work has been adequately performed at the level that the engaging entity agreed to. And of course, those independent contractor agreements can provide provisions addressing disputes over the quality of work performed, including, if necessary, the cancellation of the contract for poor performance. The line really is drawn with that as compared to traditional employee supervision and discipline. For example, with a W-2 employee, an employer might have a process where they engage in quarterly reviews, and then if the employee's performance hasn't been satisfactory, they're placed on a performance improvement plan. It's directed through HR. It's a different and much more detailed and controlling process than just reconciliation of invoices or ensuring that the work performed has been adequate. So what are the tests? We've gone over some of the factors. Those factors are all going to be considered. What are the actual tests? Fortunately, this is not an entirely easy answer. There are hundreds of different tests in the U.S. that are applied by different agencies at different governmental levels throughout the country. Generally, with some very notable exceptions, especially in California, Many of these tests consider the same factors. The determination, again, comes down to the degree of supervision, direction, and control exercised by the engaging entity, and whether the independent contractor has discretion and control over the means and manner of their work. Just as an example of how many different tests there are, at the New York State Department of Labor, my former employer, they technically have different tests for the independent contractor determination with respect to, for purposes of the state unemployment law and then the state wage and hour law. They technically have, quote, different tests. It's impossible to cover the specifics of each of those tests in this webinar, but generally they do look at the same factors. They apply a common law test, looking at different things, manners of control, weighing them, and then kind of just tossing it up and saying, okay, well, these factors weigh the, quote, employer, these factors weigh the finding of independent contractor. On balance, we're going to find either independent contractor or employer. So generally, hallmarks of a independent contractor relationship: they are engaged on a 1099 instead of W-2 basis. The burden tends to be on the alleged employer to prove that they are properly classified. As Matt will address later, that misclassification finding can be very significant. It can result in monetary costs. It could, in some cases, upend an entire business model. It could cause harm to a brand reputation. So employers or alleged employers, if they are ever challenged, will have to make the determination. These litigations are costly. They're difficult to defend because they are so fact-intensive. Is this the type of thing that is resolved through a settlement and we move on? Or is it the type of thing where it's defending an entire business model, really, and just has to be defended to the end? So the IRS 20 factor test, I actually like using this as an illustrated example, and rest assured we're going to share our slides too, so you'll have these. This test it's got so many different factors. This is the test that the IRS uses to determine whether or not somebody is liable for W-2 tax withholdings. But it's got so many different factors that it really kind of encompasses what most other agencies look at when they're weighing whether or not somebody is an independent contractor. The other agencies might not call it a formal 20-factor test, but they're probably looking at these factors as well, and they're going to consider them relevant. It's not a one factor determinative test. There are, there's a weighing that courts and agencies undertake when they look at these factors. But you could see that many of them, again, they come down to control, supervision, training. For example, an independent contractor is being engaged for their professional services that they market to the public or to a specific industry. There should be no training involved by the contracting agency, or excuse me, the contracting entity. Courts will look at whether there is a continuing relationship. For example, is this relationship lasting for years? Courts and agencies tend to say that independent contractor relationship should be for a specified time period. Unlike employees, they shouldn't have a continuing working relationship with the engaging company. The work hours should be set by the independent contractor. That is, the independent contractor has control over the hours that they work and that the time that it takes them to accomplish that work. Similarly, they should have control over their schedules, really, in terms of they're free to work when they choose, where they choose. Of course, within the boundaries of the contract, if they are engaged to complete a task by a certain end date, that is just a contractual obligation that they've bound themselves to. But they're not like a typical employee. We expect them to punch in at 8 a.m., leave at 4 a.m. They really should have discretion as to when they complete that work and the time frame for doing so, unless it's separately contracted. The FLSA, which is the Fair Labor Standards Act, that's the federal wage and hour law, they look at something called the economic realities test, which again looks at many of the same factors. I find that in New York State, for the Department of Labor purposes, they also incorporate this common law test, which looks at things like integration. Does the independent contractor perform work that is integral to the employer's business, or are they truly being engaged for some specific purpose that the employer cannot do for themselves? Other things like we've discussed: profit and loss, investment, skill and initiative, the length of the relationship, but probably most importantly, control. How much control is exercised by the employer? Or, I'm sorry, the engaging entity and the alleged employer. I catch myself doing it. I do want to just raise this, the Darden test. This is something that the Supreme Court fleshed out back in 1992 for federal contractors. It's worth noting because if you are a federal contractor, this is going to apply to you. This is going to be the test that determines whether or not you have to include an individual in an affirmative action plan, whether they are an independent contractor or an employee. It's interesting because so rarely do we get these types of employment law cases that go straight up to the Supreme Court, but this is the one that we do have. And you could see that these tests, the factors, are basically the same as those that we address in the IRS 20-factor test and the common law test. So with that, again, we've covered a lot. It is a lot to cover. We'll be sharing our slides. Feel free to reach out to us for more specific questions. I want to pass it to my colleague, Rick Reyes, to talk about this new New York Freelance Isn't Free Act, which really prompted this entire webinar. It is a new New York state law. It is very important. It has specific requirements for engaging entities in New York, and many contractors within the state are going to have to change their current agreements to ensure compliance. So with that, Rick, I'll pass it to you.
Thank you, Paul. Thank you. Great presentation. So we will now switch gears a little bit and talk about the New York's Freelance Isn't Free Act, or the FIFA. If you're a soccer fan, this will resonate. That's a good way to remind you of what the new law is going to require. So let's just dive into it. So what is the Freelance Isn't Free Act, or FIFA? So, as some of you may know, this is not entirely a brand new law. Those companies who have been doing business in New York City already had its own city-specific version of the state FIFA. So now, virtually what the state has done is to follow and adopted a statewide requirement to regulate independent contractor relationships. So today, what we are going to go over are the four main points about the FIFA, which are: who is and isn't covered under the law, when do the requirements of the FIFA apply, what are those requirements, meaning what do you have to do when dealing with an independent contractor in New York State, and finally, the potential risks for failing to comply with those requirements. Now, I want to know that even though the law was initially supposed to go into effect this upcoming month, in May 20th, the effective date was actually pushed out to August 28, 2024. So now the FIFA will apply to any contracts between New York companies and independent contractors, or what the law calls freelance workers, on or after August 28, 2024. So make sure you mark your calendars for this particular date. Now, let's start with who is and isn't covered by the FIFA. The FIFA applies specifically for what it defines as the freelance worker, which is an independent contractor who is performing services valued at $800 or more for a company. And let's put a pin on this $800 threshold, as I will be talking about it in more detail in a minute. But most importantly, and this probably doesn't come as any surprise to you all, but the FIFA applies to practically all New York employers. The law only contains very, very narrow carve-outs or exceptions to who it doesn't apply, and it includes the government at the local, state, and federal level, attorneys, licensed medical professionals, sales representative as defined in the statute or the FIFA, and construction contractors as well. Now, a company must comply with the FIFA when two conditions are met: when it hires a freelance worker, meaning an independent contractor, and the services are under the contract are worth $800 or more. Now, let's talk a little bit more about this $800 threshold. There are two situations in which the $800 minimum is met. The first one is if a single contract for the services implicates $800 or more. So, for example, let's say that you hire a plumber to repair the plumbing system at your brick and mortar facility, and the cost of repair is $1,000. Under this scenario, the FIFA would automatically apply because it's in excess of the $800. But there's also another situation in which the FIFA would kick in, even if in a single contract, the services are not for $800 or more. So this situation arises when an independent contractor when the company and the independent contractor have entered into multiple contracts in the past 120 days, meaning within the last 3 months, and the total value of those contracts in the aggregate is more than $800. So taking again the example of the plumber that I just discussed, If, for example, you hire the same plumber on 3 different occasions and each service only costs $100, $200, and $600 in the last 3 months, respectively, the aggregate would be $900. So in that situation, the FIFA would also apply. So you have to be mindful of the temporal scope of how many times you're entering into a contract with a freelance worker to catch this type of situation. Now, probably the most important part of the FIFA is what does it require? And put simply, there are 4 main requirements, which is 1, a written contract, 2, the timing and manner of compensating freelance workers, 3, record keeping, and anti-discrimination requirements. Now, in the interest of time, I'll briefly discuss each of these requirements, but they're pretty straightforward. So as for the written contract, the FIFA requires that the parties enter into a written contract, right? So that's the main requirement. Now, before the FIFA was enacted, entering into a written contract with independent contractors was a recommended practice, but now moving forward, it will be mandatory and a requirement under state law. Now, the law requires that at a minimum, the contract include the 6 terms in your screen, which includes the name and mailing address of the parties, a list of the services to be provided under the contract, the value of those services, the rate and method of compensation for the services, the date in which the independent contractor will be paid, or how such date will be determined if the contract is silent on a specific date, and the date by which the freelance worker must submit a list of the service rendered under the contract. Now, let me make 2 important points about the written contract requirement. First, you have to provide a copy of the contract to the freelance worker. Again, pretty intuitive, and this can be done either in a physical copy or an electronic copy of the contract. Second, although the law spells out these 6 key terms that need to be included in the contract requirement, the law also provides that the labor commissioner may require additional terms to be included in those specific contracts. As of today, we're not aware of any such additional terms because the law hasn't even gone into effect and it's pretty recent. But as we get closer to the effective date, the labor commissioner may identify additional requirements. So please bear this in mind and obviously check with counsel as we get closer to the effective date. Now, the other requirement relates to issues of compensation. The FIFA requires the manner and timing of compensation to freelance worker under the contract. Specifically, it has to be spelled out that they must be paid either as specified under the contract, or if the contract is silent as to the date of pay, payment has to be within 30 days after the freelance worker has completed the services. So what is important to remember is that companies cannot condition timely payment on the freelance workers agreement to accept less compensation than the agreed upon terms. That is explicitly prohibited under the FIFA. Now, turning to the other 2 requirements relating to record keeping and anti-discrimination. The key point here is that all contracts with freelance workers must be maintained for at least 6 years. If the records are not maintained and the freelance worker seeks an enforcement action, as I will discuss in a minute, for failure to comply with the FIFA, then the law creates this presumption that the terms of the contract, as identified by the freelance worker or the independent contractor, were the actual agreed upon terms of the contract between the parties. And lastly, again, comes as no surprise, as with many other laws, companies cannot discriminate, retaliate, or deny further work to the freelance workers for exercising their rights under the FIFA. Okay, so in a nutshell, those were the requirements. Now, what's going to happen if there is some sort of non-compliance for either the contract requirement or any other portion of the FIFA? So let me just highlight a couple of issues on this regard.
Hey,
First
Rick?
off, yeah.
Can I ask a question here? And by the way, I hope I don't get nightmares of Letitia James yelling at me. But
Absolutely.
Why do we have any sense of why the state thought this legislation was necessary when, there's already a requirement at the New York City level, and, they've passed this new law that is going to require employers, if they don't already, or engaging entities, if they don't already have it, to have independent contractor agreements. What was the basis for this?
Yeah, absolutely, Paul. That's a great question. I mean, I think that the reality of it is just public policy, right? I think that everybody is familiar with the ongoing issues of hiring independent contractors. I mean, we see it with Uber, we see it with all these new industries, the tech industry, the gig economy. I think that the legislature is really sticking to heart protecting workers. And this is just another additional layer of protection for workers to ensure that they are fairly compensated and that there is a consistent oversight over these type of relationships. As everybody knows, labor or the traditional labor employer-employee relationships are ever changing, and more so today than ever before. So the legislature is kind of playing catch up to those developments as we see them pan out in real time. Okay, so going back to the potential risks, the main two consequences for non-compliance under the FIFA are private lawsuits by the independent contractor themselves or actions by the New York Attorney General to enforce the FIFA. So what happens if you don't comply with either the written contract or the manner and timing requirements under the FIFA? So for the written contract, you could be facing $250 of statutory damages. If you don't comply with the manner and timing of the payment requirements, you're looking at double damages, injunctive relief, attorney's fees, and costs. And in addition to this, a company may be subject to statutory damages for the value of the contract, civil penalties, and up to $25,000 if it's established that the company has repeatedly violated the FIFA, which is where this pattern or practice language comes from in the law. Now, there are different statute of limitations depending on the type of claim that either the general attorney brings or the independent contractor does. I'm not completely sure what happened there, but hopefully you guys can still hear me. So as for the manner of timing and payment, the statute of limitation is 6 years, whereas the written contract requirement only has a 2-year statute of limitations. Now, I know that was a lot, and I'm sure that everybody has a lot of questions given that this law is relatively new. But, if there's something that you take out from this presentation, it's just these few bullet points. Again, remember, the effective date is going to be August 28, 2024. It is important to know that the law is not retroactive, what does that mean? It means that it only applies to contracts entered on or after that August 28, 2024 date. It also applies to almost all employers and independent contractors in the state. The main key requirement is the written contract with the items that I discussed earlier. Make sure that you maintain those contracts for at least 6 years. Failure to comply may result in statutory damages and penalties. And one last point, and this is important because we were talking about the proper classification between employees and independent contractors. The law is very clear that merely because you enter into a contract with a freelance worker, that does not mean that the classification as an independent contractor is proper, right? As Paul explained, there are different tests that apply. So you still have to go through that exercise to ensure that you're properly classifying that individual as an independent contractor. Even if you comply with the FIFA, if at the end of the day, the individual should have been classified as an employee rather than an independent contractor, the FIFA sort of falls off the spectrum. And the most important part of it is just that the classification wasn't proper to begin with. Now, with all of that, let me turn it to Matt, who's going to talk about ways in which companies can mitigate potential risk relating to this independent contractor classification and misclassification. Matt, take it away.
Thank you, Rick. Thank you, Paul. They say that to leave the best for last. I'm not too sure about that, but I am going to be the one to keep you awake and potentially get you a little scared at times, because there are big risks with independent contractor classification, or should I say misclassification. But I'll get into that. I'll also be speaking a little bit about some preventative measures that we can be doing as well, or you could be thinking about now as well if you're the type of company that does engage independent contractors, or you're considering engaging independent contractors. Now, one of the first things that I often get called to do by clients of mine is what's called an independent contractor audit. And it's as simple as, let's review all of the individuals whom you believe are independent contractors, who you are paying like independent contractors, or who you wish to engage as independent contractors. Let's look at the practical realities of those individuals to see if they check the boxes that Paul was talking about earlier on in the presentation. Now remember, it's two buckets. One bucket says employee at the bottom, the other bucket says independent contractor. Your goal is to put as many of those factors, the factors that Paul spoke about, into the bucket that says independent contractor, and to leave as little as you can in the employee bucket. And that's the way that the law is often viewed. As Paul explained eloquently before, it's a balancing test. The more in the independent contractor bucket, the more likely that individual is going to be seen as an independent contractor. So it's very important to address these issues right up front. So I would recommend that to anybody listening in now that has contractors or wishes to engage contractors in the future, is to sit down with your attorney and figure out if the classification is truly correct. Because if it's not, we can often prevent so much harm by fixing it. Maybe we have to reclassify this person as an employee, or maybe we need to just do a few things differently so that that independent contractor bucket gets more filled, right? And that's so important to do from the onset. I usually recommend to all employers in December, January, open up your books, let's look at who you have, and let's see if there are any issues, any red flags. Now, before the FIFA law, as Rick explained, New York State itself really didn't have a standard requirement to have an independent contractor agreement in writing with all of these, certain nuances. However, Rick, Paul, and I, for years, have always recommended that employers and contractors who are engaging contractors have these written agreements in place that govern the terms. And one of the most important things that we can do is put certain terms in there that can help spell out what happens in the case of an issue, or it can help define the role better, as Rick was explaining. And as you'll see here, under the bullet that says Step 2, worker acknowledgments with arbitration agreements and class action waivers. That is paramount and often overlooked for people engaging contractors in New York. And of course, there's a balancing scale with that. There are pros and cons of having arbitration agreements with class action waivers. However, one of the biggest pros is to prevent a misclassification class or collective action, which, as I'll get to in a bit, can be extremely costly and burdensome for a company. Other things that we can do here are have certain indemnification provisions in the contract. And as you were listening to Rick moments ago, there are no requirements to put in indemnification language, but it is a good idea to have that. So again, things that we can address from the onset and put into that agreement to help better give us that chance at showing that these individuals were in fact correctly categorized as contractors. So some of these red flags may seem familiar. Paul was harping on some of these earlier in the presentation, and he said one thing that was absolutely right and always rings into my ear is supervision, direction, and control. If you don't remember anything today, remember that you need to have your agreements in writing by August as per the FIFA law, and supervision, direction, and control. One of the things that we see often here is, if you look at bullet number 7, I see doing the same work as an employee. Imagine a scenario, let's say in a manufacturing plant, where you have somebody on the same line as someone else. Individual A is being compensated as a W-2, and individual B is contracted as a 1099, doing the same job. That is inherently a red flag. We see this often in healthcare, where we have certain clients or potential clients that have nurses who are W-2 and then nurses who are 1099. And maybe some of them are come from an agency, and we'll get to that. I've already seen some questions about that. And we'll continue to do that. But as you can see here, a lot of these red flags are items that Paul hit earlier on, and it's something to keep in mind when you're deciding, okay, is this individual truly a contractor or are they an employee? And remember the important thing here, and it was the first slide that Paul introduced, is the person is either an employee or an independent contractor. You cannot be both, and there's no in between. However, there can be two employers. Now, we'll get to that when we talk about joint employment, and that's the issue. And I know certain people have questions regarding agency issues and how that works, and I'll be addressing that as we continue to move forward. So again, this should sound like a repeat from earlier, but these are some of the issues that when we're doing this audit, when we're sitting down and we're looking at these individuals and seeing whether or not they're truly a contractor, what is the real relationship? Do not approve reimbursement for business expenses, one of the biggest ones at the very bottom. That is a huge factor that I find that both the courts and the Department of Labor look to. And I want everyone to sort of go back to Rick's plumber analysis about, the value of the contracts. But some of these laws are written so long ago that they really look at an independent contractor as simple as that. Imagine you are a homeowner and you hire a plumber to come fix your sink. The plumber is going to tell you the price mostly, and maybe you'll go back and forth and negotiate. That plumber will be wrapped up after the sink is finished. At the end of the job, you'll pay the plumber, and the plumber will go down the street and work for somebody else. That simplistic view is really kind of how all of these laws were originated, in such a non-controlling, hands-off fashion. And of course, as things have developed over time, and gig economy clients and tech company clients have sought to engage independent contractors more and more, it has expanded. But so much of it is archaic in that they look at it in such a simple lens that I just described. So let's get on to some of the issues that happens if you misclassify an individual as a contractor when maybe they should have been an employee. And we're also going to get into the joint employment issues that come along with it. So one of the ones that everyone thinks about naturally from a misclassification perspective is the wage and hour issues. Overtime, minimum wage, right? There are a lot of New York specific rules and regulations that employees are entitled to and benefit from that independent contractors are not. And it's one of those laws where it's all or nothing. It's black or white, even though often the argument is gray. You're either a contractor or you're an employee. So you fight a case all the way to the very end, and the judge is either going to say, yes, this person was an employee, or no, this person was a contractor. And the judgment's either money to pay that particular individual because they were an employee and not a contractor, or nothing. Or it could be zero because you did correctly classify them. That's one of the ones that everyone thinks about. However, there are others. And the first one I'd like to draw everybody's sort of attention on right now, if you're dozing off, wake up a little bit to this one, because this one we're seeing more and more, and I'm starting to see them in tandem. I mean, workers' compensation and unemployment insurance audits, investigations. They're usually triggered when you have a contractor who should not apply for unemployment, but does nevertheless. We saw a lot of this in the pandemic times where contractors, like employees, were applying and getting benefits, right? However, when Department of Labor gets these in, they review, and initially the individual says, well, here are my 1099s, I was paid as a contractor. And then the conversation develops into, well, you're not entitled to certain benefits under the law because you were a contractor. Well, wait a second, let me talk to you a little bit. Let me see if you really weren't an independent contractor or if you were just really an employee. And then there's back and forth with that. And we're seeing the Workers' Compensation Board sort of tag team with Department of Labor and sending out concurrent letters looking for outstanding workers' compensation benefits and payment
Matt,
and unemployment. Yes, go ahead, Paul.
In your experience dealing with, that circumstance you just described where it's an audit from DOL, do they care at all about the implications and, the obligations that the 1099 contractor has? They too, might owe they might owe taxes, right? Or are the DOL, in your experience, completely invested and interested on the alleged employer side?
Well, that's a great question, and I get that almost the first 10 minutes of every call with a client about an issue like this. And the answer is the Department of Labor is really vested in that individual, and they're not always focused on the tax implication of that arrangement, meaning the back taxes that weren't paid by that employee, but they're more so focused on the back taxes that may have not been paid by the employer, as well as the uninsurance contributions that weren't paid. For those of you who have W-2 employees in the state of New York, you understand that you have to pay certain workers' compensation premiums and certain unemployment insurance premiums for those workers that you do not have to pay for contractors. So this is a dangerous new thing. It's been around, but it's starting to be new in the sense of we're seeing it more and more. And what's also important to understand is we're seeing this on a class-wide basis, meaning if just one person applies for unemployment, let's say, and they have an issue getting it and you get audited by the Department of Labor, we're seeing that Department of Labor now expand the scope of all people who you consider to be 1099 contractors in the last 2, last 3, last 6 years in the state of New York. And let me see them too, because maybe they were misclassified the same way that Mike Smith was, who came earlier. So be on the lookout for these. It's super important to have your classifications done right. And you'll also see on this slide as well, there are some issues from the IRS, the other federal agency perspective, as well as benefits, certain benefits that are certain premiums that aren't paid into, that ought to have been paid into. Those could arise certain issues in the future as well. As we just discussed, federal agencies such as the United States Department of Labor, state agencies such as the New York State Department of Labor, labor unions who are saying, hey, wait a second, all these people should be employees, not contractors. I'm not getting my cut either. And what you should see and what you should take from this message here is that there are a lot of people, there are a lot of entities, there are a lot of agencies that are out there looking out for the employee or for the worker. But there's also that same tension of money, right? Everything revolves around money. Every time you classify somebody as a contractor and not a W-2 employee, the state of New York makes that much less money. And it's true. It's a tax issue. It's a money issue. So, of course, the laws have been implemented to protect people. Yes, of course. However, we all need to understand that there's also another competing interest at play. And we're not always judged in a fair forum when we're at a New York State Department of Labor where the state of New York is requesting owed taxes. It should seem a little funny because it is. It seems like they're all playing for the same team and everybody's against us. And it could feel that way because sometimes it truly is. These are other issues as well that we sort of touched on: unemployment benefits, tax issues, Affordable Care Act, workers' compensation. These are all things that you weren't really looking into or you weren't giving this individual because of the way the arrangement was. This was your contractor, not your employee. These are all things that could come back at the end or in litigation as wants and requests and as damages. So I touched on this a few minutes ago, and I direct you to the title of this slide, that joint and several liability is real. And it's true. You can have 2 or more people on the hook for the engagement of one individual. Okay? Joint employer, meaning corporate A and corporate B could both be found under the law to be the employer of individual or employee A. Both of you can be, not just one, but both. Now, a lot of people, and I've seen questions coming in about the agency. We have an agency that gets employees. They pay them as W-2, but they send them to our facility and we don't pay them. We don't do any of that. Could we possibly be an employer? How could that be? And the answer is yes, you absolutely could. If you fail the factors that Paul described earlier on in this presentation, and that individual, even though you don't pay them, is starting to really look like your employee because you're telling them what to do. You're the one explaining that they need to show up at 8, they need to punch out at 12. You're the one that's disciplining them. You're the one that's terminating them. You're the one that's training them. Even though those are obligations that may have been and should have been done by the agency, but yet as time went on, you started taking over those natural responsibilities. So yes, there are certainly scenarios, and I'm going to show you a slide in a few that describes some recent ones that have come back in the last year in the media of employers being hit for joint and several liability with an agency and a regular employer where the regular employer didn't employ them. Now, that's what they said. So the important point to remember about joint and several liability is the amount of money that could be owed is jointly and severally liable to those who could owe it. So if your other partner, the other corporate A, only has $5,000 in assets or money and the judgment is for $100,000, that means that they're going to probably come after you for the 95, even though you may have only owed 10 because you did so little and you were so uninvolved with this individual. It doesn't matter. It goes after everybody and they collect what they can from whoever has it. And that's the scary part about this particular types of laws that are at play. So I'm going to go through this very quick. Paul and I had done an article a few months back on New York's Manhattan's district attorney office passing this wage theft bill to create this wage theft fund. This actually, for the first time in New York, really, though there is legislation in the labor law that discusses a potential criminal imposition for an employer, it was rarely ever acted upon. This here makes it an explicit criminal crime charge if you are found to have stolen wages. And that could be as simple as you categorize somebody as a contractor when they should have been an employee and you did not pay them overtime, and you, in theory, could be found liable under the statute. There was an article written in the paper a few weeks ago about a particular pizzeria in New York City who the owners were both arrested and charged for larceny under this and had to pay $20,000. So again, going to mention this quickly. This is just something that's out there. You need to understand it's not just civil potential penalties in terms of money and reputation damage, but it could also be criminal. So here's the slide where I was discussing earlier about some particular employers or general contractors who also engaged with a staffing company, where that staffing company was the one who paid the particular individual, not them. And these are some of the judgments or settlements that have come down in the last year that I wanted everyone to sort of be aware of. This could be real money. So sort of to sum up what we've been talking about here, if you remember anything, remember the less supervision and control that you can have, the better at establishing this particular individual as a contractor. If the contractor has their own established business, great. Again, not determinative, but just another factor. If you can limit the engagement, think about the plumber in your home. The plumber only comes in once he fixes the sink, he leaves, and they're done. Maybe they'll come back if the upstairs sink breaks, but they're done. Limit the amount of time that person's on. We like to always have end dates in our independent contractor agreements if we can. We like for there to be a negotiation of the prices if we can, right? Think about that plumber. The plumber comes in, they say $400 to fix the sink. You say, how about $300? Well, the plumber says, all right, $350, I'll do it. That sort of simple view of an independent contractor model is what some of the judges, some of the courts, and some of the agencies still sort of look at when they think about these claims. So on the left, risky practices, don't do these things. On the right, things to do, in combination with what Paul was saying and as Rick explained about the new FIFA law. There are a lot of things happening in the independent contractor space. There are a lot of initiatives. There are a lot of plaintiff attorneys looking for individual companies that hire these people, especially companies where their entire model focuses on the 1099 model. And, oftentimes with them and, some of the listeners out there right now, you may be one of those companies who you focus your practice exclusively on 1099, right? Think of the gig economy clients. You can't just change everybody over to W-2. It's not that simple. It comes with such a cost or a burden, and one that you may never be able to handle. So in those instances and in other instances where we're looking to see what can be done, remember that there are always preventative things that we can address. There are always things that we can do to lessen the blow before it happens and once we become aware of the issue. It's a matter of staying on top of it and really looking at each individual whom you believe is a contractor in a separate lens on a case-by-case basis. So I hope you learned something from all of us, Rick, Paul, and myself in these last 55 or so minutes. It's a lot to take in. There are a lot of great questions that have come through. We've tried to answer some of them throughout this presentation as we can. As Paul said earlier, we will be reaching out to some of the people who have asked questions along the way that we were not able to address. But Stephanie, I will turn it over to you. Thank you, everybody, and I hope you all enjoyed this presentation.
Thank you. Paul, Rick, Matthew, thank you so much for providing us with this walkthrough of independent contractor policies, the risks that they can present, especially to New York employers. Since you guys are really just filling the Q&A box with questions, we have almost 50 questions, which is an incredible amount. Today, I think we'll just jump in with the demo. So I'll take another moment for you guys to go ahead and answer the poll that you may see on screen. If it's not on your screen, then you may have to exit full screen mode. But with FIFA policies going into effect in August, now is a great time to ensure your ICs are properly classified. With independent contractors presenting so many pitfalls, it's critical you don't leave your compliance strategy up to chance. So again, Paul, Matthew, Rick, thank you so much for your presentation today. And I think that will conclude today's event.
Yes, thanks. This is Paul again. Thank everybody for attending. You've been a very active audience. We have a lot of questions. We've endeavored to, as we walk through our slides, to answer them. To the extent we weren't able to get to a specific question, as Matt and I said, we will reach out separately, or feel free to reach out to us. But just sit back, you'll hear from us. And again, thank you so much, and have a great rest of your day.
Thank you, everybody. We appreciate your attendance.